C-SPAN 3.
Washington Journal continues.
We are joined by Maisha Braden of the Lawyers Committee for Civil Rights Under Law and Jeffrey Clayton of the American Bail Coalition to talk about efforts to change the cash bail system in the United States. But first, Jeffrey, can you explain to those who don't have experience with this system exactly what cash bail is and how it works in America?
Absolutely. So the way bail works in America, it's really a process of release, and the question is, how do people get out of jail? The first question we ask is, are they bailable? In other words, is there a hold, whether it's immigration or they're on probation or parole, that stops them from getting out altogether? And then the question is, what security are they going to put up to get out of jail? And in the United States, primarily in felony cases, it's less than a majority will post some sort of a financial security. When financial bail is ordered, typically there's several ways that it can be posted, either by property, posting your own cash, having a third party post a property or cash for you, or calling a licensed bail bondsman to post your bond to get you out of jail. Ultimately, when you show up for court, if you don't show up for court, then there's a forfeiture process where the person who put the security down will lose that security if the person doesn't appear in court.
Now, Maisha, is this a national policy, or does each state have its own bail system that it works under?
Both. There is a right to bail. Both the Eighth Amendment would suggest that, as well as the Judiciary Act. So bail has existed in the nation for many hundreds of years. However, in each jurisdiction, the implementation of that bail system occurs in different ways. The ideal system does not rely on money or monetary conditions in order to determine whether someone is released. There are many other alternatives beyond money. And for the Lawyers Committee for Civil Rights Under Law in particular, our concern is with promoting equal justice under law. And in a monetary system or a cash bail system, the poor, and particularly African Americans, are disadvantaged because the bail system becomes a system for determining whether you are having one type of justice because you have the money to obtain that type of justice, or whether you miss out on the opportunity for justice and liberty because you're poor.
Jeff, do you agree that the monetary bail system is unfair to those who don't have enough money?
I certainly think it can be. And a lot of times I think judges and lawyers don't take the time to have the appropriate due process to tease out these issues, particularly in municipal courts at lower levels. And I think that's where we've seen most of the problems is in municipal court, where you have people sitting, the Maurice Walker case that's pending before the U.S. Supreme Court right now, sat in jail on $160 bail for 10 days. And that just can't happen in America anymore.
So how many states still use monetary bail, or is that the system all around the country? Either one of you want to jump in on that one?
There are monetary bail systems existing in every state, and there are differences within jurisdictions in each state.
Now, when you say jurisdiction, are we talking counties, cities, towns, statewide? What are we talking when you say jurisdiction?
Yes.
Okay.
Yes. Now, certain jurisdictions, or actually one state, New Jersey, has done away with money bail for all purposes and intents. The District of Columbia does not operate under a money bail system. The federal system is not really a money bail system, but within any given small town, jurisdiction, or location, money bail operates.
Mm-hmm. Now, Jeff, what is your coalition's position on monetary bail? Or do y'all think it should be reformed? Should it go away? Should it stay? What's y'all's position right now?
We think it should be reformed. We don't think it should entirely go away. We think it's an option, it's a pathway for people to get out of jail that we shouldn't get rid of. And whether we have other alternatives, I think that's really the question. So if you go to our website, ambailcoalition.org, you'll see that we have what's called the fourth generation of bail reform in America. And primarily it's due process, cracking down on the use of the system as a collections mechanism, and trying to get rid of some of these nuisance sort of bails at the lower level that are just ensnaring people that don't really do anything.
Now, what was the origin of the monetary bail system in America? Is this something that existed before the United States? Did it come out of England, or was it created here in the U.S.?
It came out of England, dates back to the Magna Carta in 1275. Alexis de Tocqueville criticized bail in 1835, and so it's existed on this continent in one form or another for a very long time.
Okay. And what type of efforts is the Lawyers Committee putting forward across the country to get these type of laws reformed or changed or eliminated?
The Lawyers Committee operates primarily as a litigation house. If there's an opportunity to bring litigation to advance policy reform, we do so. One thing that the Lawyers Committee is doing that is not happening, whereas most efforts at bail are looking at money bail, fixed money systems, the Lawyers Committee is also looking at the issue of consumer bail options and improving the way that states are enforcing the mechanisms for regulating the commercial bail system. We currently have a piece of litigation going in Maryland. There is a bail operator who is not properly licensed and seeking to obtain nearly $900,000 in penalties back or payments from citizens in and around Baltimore, people who are least able to pay these types of premiums. But they have filed lawsuits to obtain payments when they should not have been operating as a bail company in the first place. The system is so large, it is so vast, that judges, prosecutors, public defenders have a difficult time regulating and paying attention to what's happening. And so many times, efficiency overrules justice. So any opportunity that we have through litigation primarily, but also through public education, through policy reform, we try and apply those levers, put pressure to those levers.
I want to get our viewers in on this conversation. So if you are in the Eastern or Central time zone and you want to join this conversation about the cash bail system in America, we want you to call 202-748-8000. If you are in the Mountain and Pacific time zones and you want to join this conversation, I want you to call 202-748-8001. And if you have experience with the cash bail system and you want to talk about ways you think that it could be improved or what you think about the system overall, we want to hear from you at 202-748-8002. And keep in mind, we're always reading on social media, on Twitter at C-SPAN-WJ, and on Facebook at facebook.com/C-SPAN. Now, Jeff, is there another option to the monetary bail system? Because I know everyone wants the system to improve, but as soon as someone is released and commits another horrendous crime while they could have been in jail on bail, everyone will say that the system should go back. Is there another more reliable option than the monetary bail system?
There is. I'm not sure that I support it, but everybody sort of tends to play this Willie Horton card on this issue, and it's unfortunate because the reality is crimes while on bail are actually pretty low. And the reason is because the time periods are pretty short. And they're actually lower in felonies than misdemeanors, if you can believe it, because they're trying to be a good boy because they know the hammer's about to come down. But the alternative is really the federal system, the system of preventative detention based on risk assessments. And what we're seeing, at least in some states that are going in this direction, is that when judges don't have the option for bail, they'll lean more heavily on detention, which is what we saw in Baltimore during the first year of their new program.
Maisha, I'm going to put the exact same question to you. Is there a better option than the monetary bail system? And what happens if someone gets out of jail, they were not on monetary bail, and they commit another horrendous crime?
That is such a rare circumstance. I don't think that should be the basis for our consideration because it rarely happens. Bail and monetary bail do not have to be the same thing. There are multiple ways to ensure that people obtain their right to bail. They retain their right to liberty. When a person is accused of a crime, they are accused of a crime. They have not been convicted of a crime. So we have to uphold the principle that a person is innocent until proven guilty by allowing a person to bail out either through an own recognizance bond where they sign and agree to come back, or if they sign and agree to come back, if you don't come back, you're forced to pay. If there are property bonds or certain conditions of release, for example, that is the ideal system, a system that looks not only at the risks of a person not returning to court, but also the resources necessary to ensure that a person returns to court. For example, studies have shown that a simple reminder via text is very, very helpful for ensuring that a person returns to court. Some people have trouble with transportation, so a court looking at whether or not the person has the necessary transportation to return to court, that the person has child care, that their job considerations have been made. If the person has a drug addiction problem, that they are obtaining drug treatment. If there are mental health issues, that they are obtaining the help that they need. Those things are better indicators, and they are more likely to assure a person's reappearance at court than simply paying money bail. And of particular concern to people of color and people who are poor, when there is a fixed monetary system, then your access to bail becomes dependent upon your ability to pay.
Now, define what fixed monetary bail system is for us, so we know what you're talking about.
Fixed money bail means that the amount of bail is set to the crime that you have been charged with. And therefore, if two people, say, for example, are charged with drug distribution, the person who somehow has money or access or resources who committed that crime gets to walk free. That person who is free is better able to assist in the preparation of their own defense, to have discussions with their attorney, to examine evidence, to help locate witnesses. But the person who can't afford to pay that fixed money bond is forced to remain in jail. That person is more likely to take a guilty plea. That person is also more likely to be sentenced to incarceration. And if sentenced to incarceration, that person is more likely to receive a longer sentence.
Let's let Tony, who's calling from Ocala, Florida, join in this conversation. Tony, good morning.
I could spend like 10 minutes talking to these people, but I wanted to bring up a couple of points if I could. First, I'd like to ask the guests how they feel about maybe replacing what we have now with common law. And, you know, what I found out in my research is that courts are a for-profit system, and each case creates a bond that is sold to investors, and eventually the big banks profit from this. And judges profit, and Britain profits, and like murder, for example, is $1 million case. And if you ask me, the problem lies with the Bar Association. Bar Association is British authority register. So they basically have control of our entire court system. And again, I'd like to ask them how they would feel about changing over to a common law system. Thanks.
Jeff?
Well, I think he makes one point that I agree with, which is we cannot continue to fund the criminal justice system on the backs of criminal defendants. And I presented to a group of judges who burst into applause, because the reality is that's not going to help people rehabilitate themselves. If we saddle them with all these fees and fines and all this stuff going forward, it's not going to help them get to where they need to get to. And as my colleague here has said, you know, substance abuse, mental health, co-occurring disorders, I mean, these are real problems. And we need real solutions, and we can't, you know, sort of fix the bail system to fix that. We need to think bigger, I think. But primarily, getting rid of fines and fees and stopping the government, the court system, and the criminal system being funded off of fines and fees, I think, is an important move forward in this country.
Aisha?
I absolutely agree. The problem of offender-funded justice has simply gotten out of hand, and the Lawyers Committee brings litigation to address fines and fees as well as pretrial conditions that result in money bail. But Tony hits on something I think that's very, very important. The bail industry is an industry. There are insurance sureties who are making upwards of $2 billion a year from the operation of a bail industry. And Judge Skelly Wright once said that, you know, the bail bondsman holds the key to the jail in his pocket. And that's because the industry that determines who is worthy of surety, who is worthy of being bail, who is worthy of taking the risks, takes a decision out of the courts. And that's a problem, because you have people whose first concern is profit and not justice, who are controlling the keys to jail and access to liberty.
Now, you said that the bail industry is $1 billion industry.
$2 billion.
$2 billion industry. Do we know how much money actually goes into the court system because of bail?
We really don't. I mean, it's hard to say, but there's forfeitures are paid by bail agents that go into the court system, and there's also jailing arrest fees that are posted when people get out of jail that also I think are wrong, but are also a source of revenue. And in some states they go to all kinds of different programs. In North Carolina, the forfeiture money goes to the school board. So there's a lot of money being thrown around.
But not much is going to the courts. The commercial bail industry is a commercial industry. They're providing a service to the courts. And the courts only receive money if a person jumps bail. But when the commercial bail industry is involved, that money is going to a private commercial industry.
Let's go to Larry, who's calling from Tuscaloosa, Alabama. Larry, good morning.
Yes, good morning. How you doing this morning?
Just fine. Go ahead.
And good morning to your guests.
Good morning.
Question here, and I agree with the attorney here and also with the other party about the court system, the way it is. But according to the Amendment 8 of the Constitution, I've been noticing on some cases where the defendant is charged with excessive bail. What I mean by that, like the crime that they committed, a person might go in and get caught with a gram of crack cocaine. Well, his bond might be $100,000 or $100,000. Well, another person might go and commit that crime and get caught with cocaine instead of crack. But his bond is lowered to $50,000, which he might be able to afford an attorney and get out. I wonder, could they change the law where the law for excessive bail won't be just punishment for the poor person instead of a way out for the rich? And I thank your guests and everybody who participated in C-SPAN and have called today. And I agree with the last caller. He's absolutely right. I think the court system is railroaded. Thank you very much.
Jeff, you want to jump in on that one first?
Yeah, I think there's tension here because everybody wants equal justice, and they say, well, we both did the same thing, so the bail should be the same. But that's not how the system works. It's supposed to be individualized, and so you'll get cases where people have committed the same crimes and the bonds are different, and that should happen if the system is functioning properly.
Thanks.
There's also something interesting in the issue that the caller raised. There have been studies, actually as recently as November, I think it's an economic journal determined that racial bias plays an issue in bail determinations. Judges rely on stereotypes and often believe that certain people are more of a risk than others. As a result, you have two people who would be charged with the same crime receiving different bail because a judge would determine that one person is more of a risk than another person. And that implicit bias, the influence of racial stereotypes within the bail system are a huge concern for civil rights advocates. So he raises a very interesting point.
Now, Maisha, California just tried to get rid of its cash bail system. Can you tell us what happened in California and whether you like or dislike what they did?
California has gotten rid of its cash bail system. A problem for many is that the system in California will now rely on risk assessment tools. Now, risk assessment has worked well in the District of Columbia. There are about 94% of the people in the DC system are released. About 88% of those people return, so it is working. However, there is a concern with risk assessment tools because they are algorithms that are man-made, and the biases that any individual who is implementing an algorithm has will be baked into that system. So a number of protections need to be put into place to ensure that there is not a systemic bias. But you weigh that against algorithms that you can program and address and fix bias against a judge who has biases that are ingrained that you may or may not know about making the determination. And civil rights advocates disagree.
Now, Jeff, you've called the California effort reckless. Why?
Well, it's primarily the move to preventative detention, and a system where we're going to label people. We're going to label people three things: low, medium, and high. That's just stupid. And what's going to happen here is that the state of California and their thirst for incarceration is going to spiral out of control if this law ever sees the light of day, and that's why it's reckless. It's a civil rights disaster, in my view, because we're going to be using the algorithm to decide who sits in jail. And the other thing is, the California Constitution doesn't allow for this expansion of preventative detention. I don't think it does, and I think, obviously the California Supreme Court's going to have to opine on that question.
I disagree that it's automatically a change from one thing to the other. It's not automatically requiring preventive detention. It's not automatically a preventive detention system. As I said, in the District of Columbia, 94% of the people are released. They do obtain bail. So I just, that characterization or that framing, I think is an incorrect framing.
Well, I think if you know much about prosecutors in California and the class of offenders that they have because of progressive reforms, I think the pressure to preventatively detain will be high. Also, the elected judge system. And if you need any evidence of that, look at the bail schedules in California that judges set.
Let's go to Joseph, who's calling from Spotsylvania, Virginia, to get in this conversation. Joseph, good morning.
Good morning. Thank you for allowing me to call in and have a discussion. Thank you very much. Three quick questions, if you will, for the panel. Number one, has ankle bracelets been effective in terms of getting people to return back to the court system? Number two, in terms of states that have elected judges, is there some data that shows the amount of dollars that bail bondsmen donate to judges in their campaigns? Therefore, you've got a reoccurring industry, if you will. The young lady made a comment about this being an industry, and it would be if continually paying the judges to keep my bail bondsman industry going. And then number three, the laws in terms of managing the bail bonds industry. I understand that how do I want to rephrase this? They're not really policemen, but sometimes they may be somewhat reckless in getting the defendant back to court in terms of how states can regulate that bail bonds person so they don't go off the deep end. I don't know how to – I think you understand what I'm talking about for the panel, but in terms of the regulation of bail bondsmen. Thank you very much for allowing me to call. Take care.
All right, who wants to start? Three questions.
I'll take it.
All right.
I'll take it. I'll go in reverse order. So the laws regarding the bail bond industry, yes, we need greater oversight. Yes, we need better laws. States in the western United States don't regulate the practice of bail recovery, meaning bounty hunters that can go have arrest powers. They're unregulated in several states in the western United States, and that's just wrong and something that we need to fix. Elected judges, I'm sure there's a lot of money going around from attorneys and bail bondsmen and everybody else, which is why we need the Missouri plan and to get rid of elected judges in the United States of America, but don't get me going on that. Third point is on ankle monitors. I don't think they generally have a great impact on appearance. I think they're more conditions of conduct, and I think ankle monitors and supervision should be reserved for higher risk cases. We can't over-supervise these low-level defendants like we're doing right now.
Joseph noted the role of the bail industry in lobbying, and we've seen that in Maryland. Maryland recently, about a year ago, passed a new rule concerning bail and requiring the presumption of release. The lobbying effort to combat that new rule was substantial. I think in the state of Maryland, lobbyists ranked third, or they spent more in Maryland than they did in all other states except two, trying to combat that piece of legislation to make sure that the industry did not lose its profit base. That's a huge problem. And the issue of not only regulation of the conduct of bail bondsmen, but also ensuring that bail bondsmen are not allowed to violate the civil rights of individuals is a huge concern. There's a case going on right now in Louisiana, Ghana, where the bail bondsman basically held a person hostage until someone could go and bring the money that they were demanding. That's a problem. And that happens in an industry that is so closely tied to profit.
We're seeing more and more people who are on probation being put under electronic lock and key, the ankle bracelets. if that works for probation, why wouldn't it work for bail?
It could work for bail. That type of ankle monitoring is a potential condition of release, as is drug testing, as is returning to check in with pretrial services. The concern becomes that the cost is passed on to the accused. And if an individual could not afford to pay bail, they most certainly cannot afford to pay the cost of wearing that ankle monitor every day. So ensuring that that cost is not passed on to the accused is a very important piece of implementing conditions of release.
Electronic monitoring.
That's absolutely right. And you look at, we just got the schedule of fees from Los Angeles County, and for a person whose average income is $60,000 a year, to be on an ankle monitor for 9 months is $9,800. That's a lot of money when you're talking about that. And so I think that's sort of the missing game, and one public defender said, if you want to understand the bad side of what's going on in bail reform, is follow the money. Don't replicate the same system another way if you don't like it. And primarily, I don't think ankle monitors are particularly effective. One, super expensive, and two, they're labor intensive. If you don't respond to a violation, then it's a worthless piece of equipment.
Let's go to Scott, who's calling from Hermosa, South Dakota, and Scott has experience with the bail system. Scott, good morning.
Good morning. I appreciate you letting me call. Yeah, I try to be flexible on my bond recommendations in my career, but your speakers seem to be this seems to be kind of pie in the sky to me. I mean, I don't know. It's I mean.
Now, Scott, let's make sure are you a bail's bondsman?
No, sir. I'm a prosecutor.
You're a prosecutor. Okay. All right. There we go. So keep going. I just wanted to be sure that we knew who we were talking to.
Sure. No, and I've worked in different systems. I've worked in state systems. I've worked on reservations. So some pretty poor places too. But in any event, it seems like the proposal here is that they want to model sort of the state system and municipal system on the federal system. And the problem is the federal system is very resource intensive. It requires a lot of personnel to make sure those pre-trial detention systems are working. And, where I've worked, we just simply don't have those resources to hire those people. We don't have the resources to buy all those ankle monitors. We don't have those kind of things. So, it sounds like the proposal is going to be very taxpayer intensive. It's going to require more money to do that because you're not wanting to put that money onto the defendants. So I worry that, this is kind of the proposal we had for the mental health system, back decades ago, where we did away with asylums and, we wanted, okay, we're going to supervise people in the community, and then the resources never came, and people were just kind of left in the streets, so that's kind of my concern with what the proposal I'm hearing is.
Maish, you want to address his concerns here?
Scott's point is valid. I am a former federal prosecutor, and he's right. There are advantages to prosecuting in a federal system. There is a robust pretrial services system within the federal system. However, I think it is problematic to sacrifice equal justice under all to economics. We can't simply say, oh, it costs too much, so we can't do it. You are talking about a loss of liberty. People suffer injustices when they are detained in jail, even for short amounts of time. They risk losing their jobs, they risk losing their homes. Single parents risk losing custody of their children. People risk losing their housing, not to mention the conditions of confinement. Being in a regimented system rather than being free, being cut off from the outside world, being exposed to the risk and dangers of being incarcerated. I think in this country, the value of liberty and the value of democracy must outweigh the value of the dollar.
Yeah.
Well, it's always good to work for the government that prints the money, isn't it? Good story. I was in Las Vegas, Clark County, and a federal magistrate was presenting at a reform panel and explaining how the federal system worked. And the Clark County District Attorney's Office raised his hand and said, Your Honor, how many bails did you set this week? And the answer was 4. And so the caseloads are huge, as the caller has said, and cost has been a primary determining factor on these reforms, at least for the last 10 years that I've seen, because the systems are primarily going to the system of preventative detention and supervision is expensive. And that's why I think, you know, if you can't go all the way there, then the answer is how many more pathways out of jail can we find for people?
But there are also other answers. Part of the problem, part of the reason that the system is so huge is that so many things are criminalized. And if we take a look at decriminalizing these low-level crimes, then you won't have a system that's so bloated. So it's not simply fixing the bail system. We must fix the criminal justice system so that so many people are not flowing through.
I agree with that, and I think, you know, if bail bondsmen are to go out of business, I think the answer is that the crimes have gone away and that we find some other form of civil accountability, whether it's restorative justice or another way, so that, you know, because the point is people just need to pay their debt, they need to pay restitution, they need to take care of what they've done, and that's really what the criminal system should be designed for. And we're just moving away from the system where we think punishment is ever going to be an effective way to go.
Right. And we also cannot forget, individuals require bail because they've been charged with a crime. They have not been convicted of a crime. Therefore, they are entitled to the same liberty as everyone else until they are proven guilty.
Let's go to John, who's calling from Washington, D.C. John, good morning.
Good morning. Yeah, I wanted to talk about the prosecuting attorneys and how they advance their careers on convictions. They don't seem to really care if you're innocent or guilty. If you go to a courtroom, they're telling the judge every single defendant is guilty. And if you're falsely accused of a crime and you're put into jail and you lose your apartment and they evict you, you come out of jail, your stuff is gone, you don't have a job. They destroy people's lives just because they're trying to advance their careers. And they make backroom deals with the judges. And the judge has often got his mind made up before he's even seen you in the courtroom.
Now, how much do judges take into account what the prosecuting attorneys think the bail should be? Is that always agreed to, or are those different numbers that the prosecutor throws out, the judge comes up with a different number? What's that process, Jeff?
Yeah, I mean, if bail's not set by a schedule, it'll happen in open court. And I would say prosecutors probably lean heavily on or judges lean heavily on what prosecutors will say. Certainly, I think there is, as the caller said, some prosecutorial, misconduct out there. I've seen it in my own career. But what I've seen more is just the under-resourced, sort of the mill situation where there just isn't time to have the type of individualized consideration in this country that I think we need.
Maish?
I think prosecutors are an essential part of criminal justice reform. Most prosecutors, the overwhelming majority of prosecutors, have no interest in incarcerating someone who is innocent. There is no career, there is no thing that makes that a part of a prosecutor's job. So I don't agree with that at all. However, the system is bloated, and there are opportunities to lose sight of the fact that a prosecutor's first job is the pursuit of justice, not the pursuit of convictions, the pursuit of justice. And there are many inflection points within the criminal justice system where we need to do a better job of ensuring justice for all.
How much is it costing the criminal justice system to keep in jail people who simply haven't been convicted but can't afford their bail? Is that costing the jail system, the prison system, lots of money in America?
It's costing an enormous amount of money, millions of dollars, and that is a part of the Smarter on Crime principles that Eric Holder discussed when he was the Attorney General, Kamala Harris discussed when she was Attorney General out in California. It is costing more to incarcerate individuals for these low-level crimes, to keep them detained in jail pending trial. And that is an opportunity for us to be smarter on crime by looking at releasing those individuals who are not a risk, who are likely to return if we put the proper resources in place. If that happens, and if we can focus on that, there is an avenue and an opportunity for bipartisan agreement, not only in bail reform, but in criminal justice reform.
Yeah, I think that's right. I think, the other thing to look at is non-monetary holds hold a lot of people in jail, and I think we need to take a look at that because...
Define non-monetary holds.
So you're on probation. A good example would be the Khalif Browder case. You're on probation for a low-level crime, and you commit another low-level crime, and then you're not bailable, and then 3 years later you get out of Rikers Island. You can't have a situation like that. So we need to look also at non-monetary holds. But we have generational mass incarceration. I don't think anybody can say that we don't. And how to solve that, I think, is the question. But I don't think policies like California, like expanding the ability for the government to detain, is going to get us where we want to go.
Let's go to Vincent, who's calling from Indianapolis, Indiana. And Vincent also has experience with the monetary bail system. Vincent, good morning.
Good morning. How are you?
I'm fine. Go ahead.
Yeah, I just had a question about the conditional release situation, whereas a person makes bail and he is low level and doesn't make very much money, but he scrapes up enough money to make bail, but then he is put on a conditional release to have an ankle bracelet or a blowing monitor, something that's going to cost him $14 a day based on his income. Now, based on his income, if that person is in for a DUI or OWI, so that situation, and he drives for a living, well, he can't drive, so he doesn't have a job. So how do they put them on that conditionary release to have him pay $14, $15 a day when they already know, and they've been explained when he went on there that he won't have a job because that's what he does. He doesn't have a license. He doesn't have a job at this time until his case comes up. And once his case comes up, if he wins, he gets his license back. If he loses or they decide to get his license back or whatever, he's without a license until that court date. So he doesn't have a job. But they still put you on this conditional release where they charge you $15 a day and expect you to pay that.
Yeah, I think the issue there is what we call least restrictive form of release. And we need to look at all sort of the basket of whether it's bail, OR release, and any type of supervisions and individually tailor it to the person. And hopefully, judges will fix a situation that the caller brings up, that if you're going to lose your job and you're still under the presumption of innocence because of these technologies, then I think that's something that judges need to take a look at.
That's why bail decisions can't rely exclusively on risk. Judges must consider resources. What resources will ensure this person returns to court? What resources will protect public safety? Additionally, just going back briefly to the issue of prosecutors, when Bobby Kennedy was Attorney General, he ordered federal prosecutors, wherever practical, to pursue no detention, no need for bail, because people should be released. That is something that prosecutors, elected prosecutors around the country can do right now. Tell your prosecuting staff to limit those opportunities where they are seeking to have individuals detained unless absolutely necessary to protect public safety and assure a person's reappearance at court.
I would just add, I think that's where we need to go back to. I mean, I think in the 70s, the movement toward preventative detention, and Dan Freed, professor from Yale University, testified to this congressional record in 1989. It basically said the original design of what we were trying to do went too far and relied too heavily on preventative detention.
Let's go to Michael, who's calling from Portsmouth, Virginia. And Michael also has experience with the cash bail system. Michael, good morning.
Good morning. My name is Michael. Just to be clear, I'm a bail bondsman in the Commonwealth of Virginia. I just want to make a couple points. I didn't have any questions. First of all, I just wanted to address Maisha. I'm a black man, and I kind of take issue with not even just the bail reform argument that, everybody who's in jail is brown and poor. I take issue with that. There are a lot of people who are brown folks, black folks, Hispanics, that are doing pretty well, and not every person who is black or Hispanic or a person of color is poor and can't make their bail. The second thing I wanted to say is that, there's something that I feel that a lot of people miss when we're talking about bail reform. We do business with family members and friends. So I understand that, a magistrate or judge can assess the situation, and they can deem a person to be indigent. But 90% of the time when I get a phone call on a bond, it's from a family member or friend call me from the outside, and they want to get their friend out of jail. And what we do is we talk with that person, and we ask that person if they're employed, if they have a job. We only deal with people who have been employed for at least a year. And we deal with those people, and those people make the payments to bail people out of jail, not the person who's in jail. So the idea that we need to do bail reform because the people who are in jail are poor is kind of a misconception. We do business with people we do business with co-signers, and the co-signers have to be at least on the job for a year, and they have to be able to make the 10% payment. Another point I want to make is that pretrial, one of the alternatives to bail, is punitive. It's essentially what it is probation before you're even convicted of a crime, and that's very problematic. If you haven't been convicted of a crime, there's no reason for anyone to be put on probation, which is pretrial services. And the last point I wanted to make is that the cost of incarcerating people across the country, I believe in Washington, D.C., it's $65 million, somewhere around that number, to implement these kind of pretrial services programs. I think California is going to cost $3.9 billion, and in Virginia, it's somewhere around $10 to $12 million for these pretrial programs. So I just wanted to make those points.
All right, Maisha, I'll let you respond.
Michael is right. I don't disagree with him. The vast majority of black and brown people commit no crimes. They are not incarcerated. That is absolutely right. The problem is that of those people who are incarcerated, they are disproportionately black and brown. He raises another very important issue. We do tend to focus on individuals who are incarcerated or detained pre-trial, but it really is the families, people who have neither committed or been accused of committing crimes, who are paying the cost. In Baltimore, or in Maryland, for example, over a 5-year period, families, individuals paid more than $150 million in bail premiums. That's not the cost set by the judge. That's the 10% on top of the cost set by the judge that commercial bail bondsmen are able to set. Of that more than $150 million, $75 million of it was for individuals who were ultimately found not guilty. So families were spending money that they did not have. Wealth was being transferred from the poor to the commercial bail industry. And that becomes a huge problem when the bail industry, A, is not properly regulated, and when individuals are operating unscrupulously. That is the problem in Baltimore. That is the problem with the case that the Lawyers Committee filed against a company for ACEs operating as Baltimore discount bail bonds. They were not licensed, yet they have obtained all of these premiums, and they are suing for recovery of additional premiums when they should not have been operating as a bail bond company in the first place. And it is the families that are suffering, not just the accused.
Yeah.
Well, the one point I think he makes that I'd like to latch on to is I think bail is a core associational right, that I have the right to bail somebody out, and it's the right to control my own destiny, our own destiny as a family, and to challenge the government. Primarily the reason there is an Eighth Amendment was the locking up of political opponents. And so if you want to sell preventative detention is a bad idea, here's what you do. You ask whether Donald Trump should have the power of preventative detention. And most people would say no, and I say, well, he's already got it. So I think bail is a core way to challenge the state when it overreaches, which is a reason we need to keep it around.
And I want to bring up something that one of our online followers has said here. This is coming from MD Veritas, and he says, listen to the callers. If you're a law-abiding, tax-paying American citizen, please realize that there are many, many people out there who sympathize with the criminals, not the innocent and the taxpayers. Is talking about bail ignoring the victims of crimes?
Absolutely not. First of all, it is problematic to assume that anyone who is charged with a crime is automatically a criminal. There are often people who are charged with crimes who are innocent. In this country, the principle of innocent until proven guilty is the very foundation of our criminal justice system. releasing a person so that they retain their liberty right while they are accused and before they have been convicted does not in any way ignore the victim. The two things are not related in any way.
Jeff?
I think we give short shrift to victims' rights in bail. I think that's changing as a result of Marcy's Law and some of these other laws that are coming into effect, victims having a right to be heard at these hearings. But I've seen cases where judges will set bail ex parte so that they don't have to have a hearing, so that the victim doesn't get to show up at the hearing. And so I think we need to do a better job getting victims' inputs in bail decisions.
Let's go to Evelyn, who's calling from Baltimore, Maryland. Evelyn, good morning.
Good morning. You know, here in Baltimore, we have bail bondsmen that what they do, it normally would be 10%, but what they're doing now is they are giving like a 1%. We have places you can go to, and they only charge you 1%. But the thing is, even if the person is found not guilty or was unjustly arrested, the family member that puts up that 1%, okay, if it's $50,000, I think 1% of that is $500. I'm not sure. And even if the person didn't do the crime or whatever, that person that family still has to pay that bail, which to me it seems like you're taking out a loan to get someone out of jail. So the family still owes that bondsman $4,500. And I remember 29 years ago, I was arrested, and they gave me a $30,000 bail. I had never been in trouble. I was visually impaired. I've been living in my neighborhood for years. My house had got raided, and I just couldn't understand why I had $30,000 bail. I wasn't going anywhere. I wasn't able to go anywhere. They don't take any of that in account. And then I also heard that, and I'm not sure, in the Constitution, I think it might have been in California, that it's unconstitutional to give a bail to a person that's indigent.
Aisha, you want to jump in there?
Evelyn hits on a very important point. The average bail is set at about $10,000. And for individuals who cannot afford to pay that amount of cash outright, they go to bail bond companies. And the premiums are set, and that those premiums have to be paid regardless of conviction. And the transfer of wealth that is happening, particularly in poor communities, by family members, grandmothers, aunties, who are taking out loans, who are cashing out their savings in order to pay these bail premiums, is a huge problem. Additionally, women are particularly disadvantaged in these systems. Women are more likely to be unemployed when they are accused of crimes and facing bail determinations. Women are also less likely to have the family supports available in order to cobble together the money necessary to pay for their bail. And as a result, these women are more likely to be detained pre-trial. There are problems across the board with the cash bail system at many different inflection points. And that is why we advocate the elimination of cash bail and reform of the bail system wide scale.
Yeah.
Well, I think all the consequences that flow from an arrest that doesn't lead to a conviction are non-refundable. And that's probably something that we should look at. I mean, I went in and told the legislator we should waive governmental immunity for wrongful or for negligent acts of prosecutors and the police. I didn't get a very warm reception because of how expensive that would be. But I was trying to make a point that maybe there is a time when it's just so grossly mishandled that there could be some compensation.
Let's go to Ed, who's calling from Jackson, Tennessee. Ed, good morning.
Good morning. Good morning. Hey, history does not furnish a single instance of a government once established voluntarily yielding up its powers to secure the rights of the people. James Madison. But look, the whole criminal justice system is a sham. What happened to it's better that 10 guilty escape than to let one innocent suffer? And also, when you compare the other countries' incarceration rates, for the other in Europe and all, they have, for every 100,000 in the population, 60 are locked up. In the United States, 600 out of 100,000 are locked up. But it's the over-criminalization of everything.
The system is broken. And then, if I can, I'll end with this. Trying to find the quote here. We can have justice when those who have not been injured by injustice are as outraged by it as those who have been. And another thing, aren't we the only country that has for-profit bail bondsmen? I think United States and Philippines.
Are we the only country besides the Philippines that have?
We're the only country that has regulated for-profit bail. I'll put it that way.
Okay.
And so, I think there's all kinds of indemnity contracts for bail, all around the world. But I agree, generational mass incarceration, it's a real thing. There's a great article by Professor Robert Worth from Rice University where he tries to tease out, why did this happen? How did this happen? And I think his argument is over-labeling people as risky, because no trial can exonerate that. Once you're dangerous, and when you do your next crime, you're more dangerous, and then more probation, more ensnaring, and it just never seems to end. I think it starts small, and it just magnifies over time. And so we have absolutely over-criminalized ourselves, and we rely too heavily on incarceration. There's no doubt about that.
That's right. I absolutely agree.
All right. Let's go to Mike, who's calling from Annapolis, Maryland. Mike, good morning.
Good morning. I had a quick follow-up question to the panel member who wanted to go back to the Camelot days where the Attorney General instructed the federal prosecutors to do pretrial release for everyone pending trial. What federal crimes are considered non-threatening to the public? I think drug trafficking, child exploitation, even some white-collar stuff is predatory in nature. What crimes are non-threatening to the public that deserves pretrial release?
It's not simply an issue of the crime. We discourage the crime determining release. There must be an individual determination. We must look at the individual who has been charged with the crime. Is that individual likely to return to court? Does that individual place the public at a risk? So the premise, I think, is a flawed premise. And I would also be concerned that we remember that in a bail system, individuals are innocent until proven guilty in our criminal justice system. And that has to be the foundation of all of our considerations when we are having discussions about reforming, fixing, or ending certain types of bail.
I'd say traffic would be my example in the federal system. And believe it or not, the federal system detains 10% of all traffic offenses. And I don't know what that is, having an open can of Budweiser cruising through Yosemite. And is that dangerous or not? I don't know. But 90% of all traffic offenses, I guess, get released. But I don't think any of those should get detained. But I guess I'd have to see what the cases are. But I think the federal system, and like my counterpart has said, is based on individualized determination, not necessarily just the conduct. And I think that's probably the right approach.
Let's go to Martine, who's calling from Salem, Oregon. Martine, good morning.
Good morning. I'm calling about this with my son. He's mentally ill. He has schizophrenia. He's homeless. Said he's been 17. I couldn't get help for the school. And what he was doing in the school was being helped through disability efforts. When he turned 17, now he keeps going to jail. So he's homeless, and he's on the streets, and he's acting erratic. He goes to jail. They set a bail. They let him out. He pleads guilty because he doesn't know what to do. Nobody will take into account the disability. One time to the hospital for 2 months so that he could come back and plead guilty. It's ridiculous. They've referred him to services. He won't go. He's schizophrenic. When he's in jail, it's a little bit of relief for me, but it's not fair to him. He keeps getting more fines on probation. He's just going to be in there longer and longer.
Now, Martine, are you the person who keeps bailing your son out? Is this coming out of your pocket?
I don't bail him out. I don't know what to do with him. He has schizophrenia, autism. I'm on disability. We don't have it. We're both on disability. I don't know what to do. I don't have the resources.
How much does the bail system affect the people who are having mental challenges?
Well, that needs to be one of the considerations. That's why we can't simply focus on risk. We have to focus on resources. If a person like Martine's son is a flight risk or a risk of harming the community because of his mental illness, simply locking him up in jail does not help him. It does not help the community. What needs to happen is this person needs mental health treatment. and having a system that provides those types of opportunities and that makes that type of consideration is where we need to be heading.
Well, we did a survey of 1,000 bail agents around the country to ask them how the system works when they deal with people with mental illness, substance abuse, and co-occurring disorders. And to summarize the gist of it, the system is poorly equipped to handle these people, whether it's pre-conviction or post-conviction. I think that's probably the number one thing that I hear traveling the country and talking to bail bondsmen is this issue of these people don't belong there, they shouldn't have been there in the first place, and sometimes the family doesn't want to bail them out because they have a severe substance use disorder and they're afraid that they'll die if they're released. And so those issues are every day, and I think it's a bigger problem than people want to admit.
Let's see if we can get one more call in from Noel, who's calling from Jacksonville, Florida. And Noel has experience with the bail system. Noel, good morning.
Good morning. How are you?
I'm fine. Go ahead.
Good. I have a two-part question, one possibly the other. The first is that the question that goes to the bail bonds representative there, and that is, what did he mean by the statement he made about working for the government to print the money?
Okay, and go ahead and give us your second question real quick because we're running out of time.
And the second question is the bail bond industry a private government, a private what do you call it, private public industry, or the government, or where the industry is actually a partnership with the government and the bail bond system, and therefore they're working for the government that prints the money?
Well, the government that prints the money is a joke because the federal government can spend all the money that it wants, and as we've seen, it tends to do that. Is the bail bond industry a part of the government? The answer is no. A bail contract, however, is a three-party contract, so the bail bond is a contract with the court, and so in that respect, I guess there is some contractual duty from the bail industry to follow through on what its obligations are under the bond contract.
We could keep talking for another hour, but unfortunately we've run out of time. I'd like to thank Maisha Braden, the Criminal Justice Project Director for the Lawyers Committee for Civil Rights Under the Law, and Jeff Clayton, the Executive Director of the American Bail Coalition, for being here with us today for this great conversation. Thank you.
Thank you.
Coming up next, it's time for our Spotlight on Magazine segment, where we're going to talk to CQ roll call reporter Kate Ackley about her piece on the NRA and its lobbying muscle. We'll be right back.
I'm always enthralled by the Senate chamber itself.